So we're at the table and we're ready to sign. And let's assume this is a cash deal, not the financing paperwork involved. What is the main documents that we're going to be looking at during signing on a cash purchase?
On a cash purchase, normally you're going to be fortunate enough you're going to be dealing with a good old fashioned HUD. That's what we did back in the old days. Now mortgages require some more extensive paperwork. You've got closing disclosures for the seller, closing disclosures for the buyer. It's a lot more paperwork intensive. But on a cash deal where you're not doing that kind of financing, you're going to be dealing with a good old fashioned HUD. And what a HUD form is, it's from, the Department of Housing, as the name would suggest. It's been around forever, and it just breaks down the terms of the deal. It'll have the property, it'll have the buyer, it'll have the seller, it'll have the sales price, it'll have whatever deductions have been made either to pay off any mortgages or deeds of trust that the seller owns. Because we didn't really touch on that, but it goes without saying, if the seller has a mortgage on a property, that's going to have to be paid out of their proceeds for the buyer to get valid title. So it
Right.
will proceeds if there is a mortgage or deed of trust or any other liens like those garbage liens or judgments we were talking about. If for some reason taxes for, say here we are in April, maybe the 2021 taxes haven't been paid. So you got to full pay that plus penalties and interest. And then in addition to that, in almost every case, unless there's a special provision to the contrary, you're going to do what we call prorate taxes because Mississippi does taxes in arrears. So for instance, the taxes for 2022 won't come out. The bills won't come out until late November. They're due by February the 1st. Because it works that way, sellers during this year, we prorate the amount that would be their taxes based on last year's bill through the date of the closing. And
Right.
I will say now, a lot of times on maybe investment property, it may not even be that much, but sometimes on a more expensive home, that's usually the amount they're like, oh, I thought I was getting a little bit more. And that's usually the amount, maybe $1,500, $1,600 if you're later in the year that they weren't accounting for those prorated taxes. But the reason is, if you think about it, the seller doesn't care if the taxes get paid or not. And you can't pay them until those bills go out and, the latter part of the year. And so the buyer's got to take responsibility for making sure they're paid and has the incentive to do so because the seller doesn't care if a tax deed's issued on the property because it went 3 years without paying the taxes.
Right.
So it takes the tax assessor's office till the next year to change the name. So the buyer may not get a bill, but we always go over all that and make sure they understand, hey, you need to go. If it's a homestead situation, which that wouldn't apply to your investors, you claim your homestead at the appropriate.
Right.
If it's not homestead at any rate, go by there. And if you've got a lot of properties, and a lot of investors I know do this, and still sometimes they'll miss one, you go over there and say, hey, pull all my properties, make sure I'm not missing one. I've got it on my list here, but sometimes things can happen. And most investors I know, every now and then they'll miss one and it'll run in the paper and like, oh, I missed one. I got to get by there. So that's not uncommon. That happens sometimes, but you do want to have a system so that you don't miss those and that those properties that you buy in 2022, that you're paying those taxes whenever you do at the end of this year or before February 1st if you don't want to have penalties and interest next year.
Gotcha. So the HUD is telling pretty much what's being dispersed and what's
Oh,
being
that's
brought to the table.
different attorneys are different, but I prefer to start with that because if we're going to have a problem, that's where it's going to be. If
Yeah.
somebody, because at the end of the day, you see how much money the seller has to bring to the table, certified funds, and then on the other side, you see how much the buyer has to bring to the table, and then on the other side, you see how much the seller's walking away with. And really, those are the two numbers that the buyer and seller care the most about. The others they
Right.
can look and add up and kind of wallow in, but at the end of the day, the buyer needs to be pleased with the amount they're bringing. It needs to be approximately what they expected. And the seller needs to be okay with the amount they're leaving with, because if they're not, the deal may not happen. And I have seen that
Right.
there was something in there, if there were some liens or something going on that they weren't happy about, I'm just not selling. And that can happen. And so that's why, you want to, as a buyer or a seller, to the extent possible, depending on the time constraints the deal has put on everybody, just say, hey, I want to get that closing disclosure, the HUD, a day or two before. And even if that means we push the date back, whatever we got to do, but I want to be able to have a little bit of time to look at that. Now, as you get more comfortable with it, you're less, what that is. You understand what's going
Right.
on, about do it yourself. But especially as you're starting out, I would say somebody that was just starting out, you're going to want to look at that a day or two ahead of time and make sure you understand it. If you don't, ask the closing attorney. They'll be, very glad to explain it to you, but just make sure you're on board. And that'll come up sometimes. Sometimes that's another thing, kind of circling back to the contract, but it pertains to this. In most cases, a typical case, the seller's going to pay for deed, title, and termite, right? So a deed's $125, title maybe $350. It depends if it's several tracks. It may be more than that. And then a termite, if everything's clean and good, $68, $75. A lot of investment deals don't even have a termite, but that's just it's inexpensive. That's a good thing to have. A deed, title, and a termite. Make sure that the house isn't eat up with termites before you buy it. And then the buyer typically pays the rest, the settlement fee, disbursement fees. So it ends up being kind of close to even by the time the dust settles. Because on a cash deal, depending if you don't get title insurance, which is another topic, but if you don't, you're probably looking at $700 to $900, give or take. And then on a title insurance policy, it just depends in reference to what the cost is of the sale. So, that's typical. And if it's not said otherwise, it's going to be kind of expected by the closing attorney. That's what's normal and customary, and that's what's done. So if that's not the deal, and I will see that sometimes, I'll see a seller say, I said I'm walking out with this much money, and that means I'm not paying anything else. And so if that is the case, it's really important to everybody to get that HUD or the settlement statement or the CD, whatever it is that applies to your transaction, so you can look at it, because it is kind of stressful to get there the day of and be like, I'm not paying that. And the closing attorney's like, well, somebody's got to pay it. And it could very well be, and I've had this happen, that kind of stuff comes up and it's on a day, maybe it's the last week of the month, which if you do much in real estate, I don't know why, but that's when everybody wants to close. Bank, parties, everybody. So we may be, or the last working day before a holiday. So, a real estate closing attorney may be slammed with 4 or 5 closings in a day. So you're talking about you're on the hour. You don't have any time to be messing around and reprinting documents. So
Right.
the negotiation is passed. If you have not seen it and it's not what you think and you can't do it, it's very possible if it's one of those busy days, you're like, I can't stop what I'm doing and do this right now. We're just going to have to reset you for another day. It's unlikely. Usually they're going to try to do it, but it's possible depending on how many and what's going on. And if this is something you guys should have been able to hash out before. So to the extent possible, it's always better to try to get a look at that and let the real estate attorney know, hey, I need to have that HUD the day before. And that way, if we've got any issues, we can let you know ahead of time. And they want that too, because they don't want to be there while everybody's there having to change everything and stop everything, especially when they're booked on the hour if they're really busy that day.
Right. All right. So we got our HUD, we've closed. I'm going to ask you a couple of terms, and then we're going to move into a little bit of creative financing.
Mm-hmm.
So what is a warranty deed?
A warranty deed is literally the document that will be recorded in the Chancery Clerk's office here in Mississippi. In different states, they'll be called different things. But in Mississippi, it's the Chancery Clerk's office, and it actually conveys the property. So, for instance, if I'm selling you a property, a warranty deed, it's going to be from my company, XYZ LLC, to your company, Chris Garrison LLC. And it's going to have our names and our addresses and phone numbers, because just in case there's any issues and the clerk needs to follow up with it, it's going to have a legal description of the property. Usually, if it all is as it should be, that's going to be at some point a surveyed description or a platted subdivision, so you can, with reasonable certainty, identify the real estate that you're purchasing. And as we alluded to before, that's not going to include any mobile homes. You're going to want to get those titles, but real estate includes the land and the fixtures on the land, which include a permanent structure like a house.
Right.
And so that goes with it. You don't need anything else for the house as long as it's not a movable structure. But that warranty deed is the actual conveyance. Now, it has to be recorded. So in Mississippi, until it's recorded, it did not happen. I see some people sometimes like, oh, I'm just going to sign it and let them hold it and they can record it. Don't do that. I mean, if you do the deal, go ahead and record it. If there's some reason that conveyance can't be made, there are other things you can do, like contracts with options to purchase. There are other things, but you definitely want to understand that you don't want to have a warranty deed that you don't record. If it's your intention for that warranty deed to be valid, you need to go ahead and record that with the Chancery Clerk's office, because in Mississippi, until that happens, it didn't happen. But that once it is recorded, that changes the ownership over it. And so the following year, the tax office is notified. All of that in Delta Computer Systems that we referenced earlier is updated to show the new owner. But the moment that deed is recorded, that ownership changes hands. That's the deed, the most important thing probably in the whole thing.
So I know we've been talking about a cash sale, but I want this term spoke about as well for our aspiring investors. What is a deed of trust?
A deed of trust is a mortgage. And what that basically means is it's a lien on the property. So if an investor or a bank or any lender to a transaction is going to be taking a lien on the property, meaning if they don't get paid back, they can foreclose. They need to have a deed of trust that is filed, preferably immediately behind the warranty deed, so nothing else has time to stick. As a purchase money deed of trust, and that's got a heightened level of protection versus, if you already own property that you want to go borrow money on, a purchase money deed of trust has a little bit heightened level of protection in terms of security interest. And you need to have that if it is your intention to have that lien. And it needs to be just like the deed, it needs to be recorded in the appropriate chancery clerk's office for your county where the property is located, so that if and when it becomes necessary because of the terms of the note not being met, you can foreclose and go through normal foreclosure proceedings instead of having to maybe go through a really lengthy court situation. Because if you have that done correctly, that's probably not going to be necessary. You're going to have a right to foreclose once the terms of the note aren't met.